Welcome back to another Courtroom breakdown, and this one is a perfect example of what happens when internet legal myths collide with reality. Today's case features a familiar face. Jonathan Schuster, a self-proclaimed sovereign citizen who believes the court has no authority over him, insists he's appearing in a special capacity, and repeatedly demands that the judge prove jurisdiction before the case can move forward. Now, if you've watched sovereign citizen cases before, you probably already know the script.
I'm here sui juris in propria persona. I reserve all rights. I, Jonathan Troy Colin Schuster, comma beneficiary and sovereign, and here for fraud, menace, and duress, fiduciary advocate. This is a Social Security Certificate Trust action, which you are now a real party and interest to. I'm here sui juris in propria persona. I've challenged the jurisdiction of this court, and I don't understand. So I do need some questions answered. Is there a bond on this matter?
I believe you were PR. Actually, bail was set at $2,000.
There is a bond on this matter, correct?
Yes, there is.
Okay, and so is my social security number attached to these charges in any way?
I don't believe so.
You don't believe so?
I don't have any record of your social security number. So as far as I know, I don't know your social security number.
No, I'm saying, is my social security number attached to these charges in any way?
Only in the extent that it's connected to your driving history.
So is that a yes or a no?
In some way, shape, or form, your social security number is in the system with records on you. That is true.
Okay, so you just told me there was a bond, which means this is a commercial court.
It's not commercial.
Now you're saying that my social security number is attached to these charges. And so, which means this is assessed a case trust action, which you are a real party and interest to. And I just told you I was the beneficiary. You're supposed to be charging the trust. You're not charging the beneficiary. And if you're creating bonds against my trust without my permission, I don't understand. Are you
Noted.
You cannot enter a plea for somebody. That is, you know.
At this point, we're already seeing one of the most common sovereign citizen tactics in action. Rather than addressing the specific charges before the court, Jonathan is attempting to redirect the entire conversation toward concepts like trusts, commercial law, and social security accounts. The underlying belief is that there's a separate legal entity attached to every person, and that criminal charges somehow apply to that entity rather than the individual standing before the court.
Further on this matter until this is either dismissed with prejudice or you can prove jurisdiction.
So what would you like to do with your case? I assume, Mr. Parent, that you are not representing?
So the man cannot speak for me.
Okay, he's not speaking for you, but I am asking him a direct question, so I need you to let him answer.
Okay.
Yes, so the court did appoint us on this matter, but it sounds like he does not want my office to represent him, so I'm happy to withdraw.
You can dismiss yourself.
So would you like to represent yourself in the matter, Mr.
Please
Schuster?
do not tell me to shut up. You can dismiss yourself.
So he can't dismiss himself, only I can dismiss him. I'm asking you if you wish to have an attorney or if you wish to represent yourself.
This is a trust or certificate trust action. And so I'm here sui juris in propria persona. You know what that means. And so we can prove.
I don't know what it means because it's nonsense, but nonetheless.
Prove jurisdiction, or we can dismiss this matter with prejudice.
So I'm not going to do that today. Here are your choices. You can have Mr. Parent represent you. You can choose to obtain private counsel, or you can represent yourself. Let's start there. Which of those three?
Nobody's going to represent me. I can present myself, as I said.
So you wish to go pro se? I don't need you to read the script. I need you to tell me if you wish to go pro se.
I told you I'm here sui juris in propria persona.
Ms. Roberts, are you there?
Yes, Judge.
My inclination is to set this matter over and see if Mr. Schuster wants to give it another shot with his attorney or go pro se. It looks like this is the first pretrial. I suspect he's not prepared to set for trial today.
What is the first one? There's no plead.
Okay, I'm not speaking to you, so you're gonna have to wait. I'm speaking to Ms. Roberts.
I mean,
Judge, I would ask that we set this matter over 1 week.
Okay. Do you want to come back to court in 1 week and try again?
we can finish this matter now.
We
There's no
can't.
need to
We
move
can't.
this any further. Because
So here's
it's
the
not
thing.
proven jurisdiction.
Here's the thing. It's not my position today to have to prove jurisdiction to you.
It is. It is your position. Because
it's
it is
not.
on the courts.
And I'm also not gonna argue with you.
There's no
So
arguing.
I'm
That's
gonna
just
have
the
you
law.
come back to court in 1 week.
There's nothing you can prove that you have jurisdiction. This man does not speak for me.
So we're gonna come back to court on July 1st.
That date doesn't work
Why doesn't it work for you?
because I'm a man.
Things have now escalated significantly. What started as a disagreement about jurisdiction has turned into a confrontation over the court's authority itself. Notice how the judge repeatedly attempts to explain the consequences of failing to appear, while Jonathan interprets those explanations as threats. This is a critical distinction. Courts routinely inform defendants about what can happen if they miss a hearing, including the possibility of warrants being issued. From the court's perspective, that's simply explaining the legal process.
And set this further because you can do that or you can dismiss this matter with prejudice.
I'm not gonna do that today. So July 1st, 9 a.m. back in this courtroom.
Threatening me. Abigail, what's the reason for the threats, Abigail? You violated my rights enough.
We'll just hold Speedy for
You
this week, Ms.
violated my
Roberts.
rights enough. This matter needs to be dismissed with prejudice.
We'll see you back on July 1st,
Or else what? You're gonna threaten me?
or else the court will issue a bench
So
warrant.
you're threatening me now, Abigail.
I am telling you
No,
your
I'm telling you,
options.
this matter needs to be dismissed with prejudice. Because you cannot prove jurisdiction. This is a
Signature here.
trust action.
Signature
You're
here,
trying
please,
to
sir.
commit fraud.
Sir,
You're
Mr.
trying to
Schuster.
commit fraud. Miss, I'm
So-
speaking with Abigail.
You're done.
No,
you're
no,
done.
you can't tell me I'm done.
I
This
can.
is no, you don't have power to do that.
Your court case is
You
over.
don't have power to do that.
Sir, your hearing is over. If you don't take your paperwork and leave the courtroom, we'll have you remanded into custody.
You're threatening me now,
I'm
even more so
Giving you
than
a
you already
choice.
were. And if anybody tries to touch me, I'll charge them with assault and battery. So I will be gone.
We can address Jonathan Schuster, 480525748.
For the record, this man.
Why don't you come up to council table, please, so we can create a record?
No, I don't wanna, and give you any personal jurisdiction, so I'll stay right here.
No, you'll come to the council table if you would like to be heard and make a record. So you need to come up and turn on the microphone.
No, I don't need to do that for me to be heard. You.
We are audio recording, so to be heard, you need to come up to the table and sit with the microphone.
You don't have to, I don't have to come up there for you to hear me. You can hear me perfectly fine.
I can hear you, but we are creating a court record,
I don't
which is
think you
audio
have personal
recording.
jurisdiction by doing what you said, because you don't have jurisdiction over me. And so, for the record,
Mr. Schuster, I
I
did,
reserve all rights.
I did
Aye.
put Mr. Parent as standby counsel. Right now, you don't represent yourself. You have
cannot
standby
appoint
counsel.
counsel to me
Well,
without my permission. He has no permission to be my counsel. I am here sui juris, appropriate persona. I, Jonathan Troy Colin Schuster, am here under fraud, menace, and duress. I have made a special appearance to this court.
As the second hearing begins, we're seeing something remarkably familiar. Despite the previous hearing ending without any success on the jurisdiction argument, Jonathan returns with virtually the exact same approach. The names, phrases, and legal buzzwords haven't changed. The strategy hasn't changed. Even the demands being made are nearly identical. This highlights one of the biggest problems with sovereign citizen ideology. The arguments are often treated as if they're magic words that automatically trigger a legal response.
Of what's going on. I don't understand how you can practice law from the bench. I don't understand how you can appoint counsel when I've told you over and over and over again that I'm here sui juris appropriate persona. I'm here of my own right, in my proper person. He does not have my permission to represent me in any way.
well, it doesn't sound like you know how to represent yourself either, which you would,
represent myself.
well, you would. Either you
I
have
don't.
counsel or
I need
you are
to
acting pro
represent
se.
myself. And so, like I have told you, I'm here sui juris and propria persona. I challenge the jurisdiction of this court. You have not answered that challenge. We cannot move any further until you've answered that challenge. Is this common law jurisdiction, or is this an admiralty maritime jurisdiction?
Either. So,
right.
Mr. Schuster, this is Carmen McDonald. I'm the prosecutor on this particular case. I think where we're at right now is you're being charged with an offense. I can barely hear you, which means the record that you're trying to make is not being picked up and not being recorded. So everything you're saying is not being preserved unless you go to the table up there near the microphone. So that's number one.
For the record,
If you would like,
step up so you can hear me better, and I will speak louder.
being
I will
preserved.
speak louder so you can hear me, but I reserve all my rights, and I'm speaking much louder than anybody else prior to me has spoken.
Mr.
So I just want to make sure the
Mr.
reporter can hear me.
You are making legal arguments. All right, you are making legal arguments. They should be preserved for the record, which means it needs to be picked up and recorded.
I will begin again so that the recorder can hear me.
You're not choosing to be silent. You're choosing to make a legal argument. So we need to have that on the record.
For the record, I reserve all rights.
You've made that.
I, Jonathan, Troy, Faiz, Olea, Somalia, Toa, Colin, Schuster, have made a special appearance under fraud, menace, and duress. Fiduciary, Jennifer. I've challenged the jurisdiction of this court, which has not been answered. This is a Social Security Sestake trust action, which you are now a real party in interest to. This is a military admiralty jurisdiction under maritime law. However, you must realize that you have no such jurisdiction without also having a valid international contract in dispute. I am not aware of having entered in any international contracts, so I deny that any such contracts exist. Will you please instruct the prosecuting attorney to inform the court if there is such a contract? And if so, place it into evidence and explain how I'm party to it and then compelled to.
This may be one of the most important moments in the entire hearing. The judge isn't saying that Jonathan lacks intelligence. Instead, she's suggesting something much more specific, that he appears to be relying on misinformation and misconceptions about how the legal system works. That's a distinction worth paying attention to. Courts often encounter defendants who misunderstand legal concepts, especially when they've relied on advice from questionable online sources. The issue isn't necessarily whether someone is capable of understanding the law.
So you're simply off base, but I don't know that it's due to a mental defect that is causing you to not be able to
challenge my competency because I have challenged the jurisdiction of this court, and you have not proved jurisdiction.
In Social Security or contracts
you
or
have to
maritime.
prove jurisdiction before we can move any further.
So that's just not how it works in this court, and
No,
I don't think you have the legal.
You must prove jurisdiction because I have challenged the jurisdiction. If you cannot prove jurisdiction, then I move to dismiss this matter with prejudice.
That's denied.
And so, Miss Jennifer, can you prove?
I'm Judge Grant, so I'm going to have you.
Can you establish the jurisdiction? Can you prove jurisdiction?
Ms. McDonald, I don't know that this is him not understanding.
I do not understand the nature or cause.
He doesn't have legal training, so that I think is
that does not matter.
Well,
if I'm here sui juris and propria persona, I'm of my own right. I'm in my proper person. You've created a bond on this matter. You've attached my Social Security to this matter. You're trying to charge my trust without my permission, which is illegal. It's fraud, and I'm not going to stand for that. So you must prove jurisdiction before we can move any further. You've already tried to practice law from the bench, which is illegal. You cannot do. You've tried to assign counsel when I've given no power of attorney to anybody.
So, Ms. McDonald, what I think would be the next steps, I don't know if Mr. Perrin, have you been able to provide any assistance to him on a standby basis?
No, Your Honor, he doesn't want any assistance.
Okay.
So I'd ask to withdraw his
So we could go through the colloquy, we can provide him with the form for rights. I don't know that he's going to choose to participate in that. But that would be the next step and set it for trial. So Ms. McDonald.
I don't have a problem setting it for trial. If he's going to waive counsel altogether, then I think we need to have him sign the waiver of right to counsel.
Absolutely. I'm just saying I don't know that he's going to participate in that process either.
Right. No, I understand
We have
that.
speedy trial at
It is the
August
burden of
9th.
the state to prove jurisdiction. The prosecuting attorney has not done that. And so what we have here is we need to dismiss this matter with prejudice. And I motion to dismiss this matter with prejudice.
Denied.
Based on the fact that the prosecuting attorney has not proven jurisdiction.
Mr. Schuster, would you like to sit at this table away from council so that we can hear you on the
This isn't
microphone?
counsel.
Well, you could sit at this table if you'd like. There's a pen and a form and a microphone for you if you'd like.
We cannot move until jurisdiction has been proven.
Yeah, it should be
You have failed to prove in jurisdiction.
Jurisdiction is something that we prove at trial. It is a factual issue as well.
We cannot move any further until jurisdiction has been proven. And none of you have done that.
Right. So Mr. Schuster, did the court say that was end of August or?
It was August 9th is speedy trial.
Okay. So.
And if you plan on having me back here, you're taking away from my ability to provide and work. And I cannot just be coming back here because it takes my time away from working. And so if you want me back here, it seems that you have Zoom court available. I'm more than happy to make a special appearance via Zoom, but you're taking away my time and freedom to provide for my family.
Does the August term start August 6th, Your Honor?
It does.
So I would request we set it during August term.
All right, so Mr. Schuster, you've been charged with driving while your license was suspended in the 3rd degree and for operating a vehicle without the required ignition interlock device and refusing to comply with law enforcement officer. You are on a deferred prosecution in another court, and the consequences are extreme for you. You are subject to another court, and they could very well
get in trouble. And you have to prove jurisdiction. You haven't done that, and you've failed.
Obviously,
to do that
you believe that courts do have jurisdiction over you.
Obviously, you have to be able to prove it, and you haven't. And you can keep pushing it and doing this, but it's just a waste of time for everybody. I definitely understand that this is not.
Here's where the contradiction becomes especially difficult to ignore. Throughout the hearing, Jonathan insists the court lacks authority over him. Yet the record indicates that he's already participated in legal processes that necessarily relied on that very authority. This is something judges encounter frequently. A person may reject the legitimacy of the system when it's inconvenient, while simultaneously benefiting from or participating in that same system at other times. The result is a position that becomes increasingly difficult to defend under scrutiny.
For what's going on here, that's absolutely ridiculous. And so
I don't think
this matter
anyone
needs
is
to be
told that you're
dismissed
being
with
put into
prejudice.
captivity.
And whether we need to take this to trial or whatever y'all need to do to prove jurisdiction, I mean, go ahead, but obviously you can't prove jurisdiction. So
I'm looking for the more
waste everybody's
detailed
time, please.
counsel
Waste everybody's
waiver.
time. It's absolutely ridiculous.
I don't know that he's done that yet.
No, he hasn't. I have the streamlined version, but I want him the formal,
The detailed one.
the detailed one.
We can also, Your Honor, just set it for trial today with an intervening pretrial, provide him with that document and enter the waiver at the next hearing prior to allowing counsel to withdraw.
All right.
Counsel should have never been appointed because I've never gave my power of attorney to this counsel. And obviously you did that to practice law from the bench, Miss Jennifer, which is illegal. You cannot do that.
Mr. Schuster, you're charged with a crime that has potential jail consequences and fines, and so your rights need to be protected. This is for your benefit.
There is no injured party. There is no sworn complaint of an injured party. This is absolutely ridiculous. It's a waste of everybody's time. And you're taking away my ability to work over and over and over again. And I won't stand for you violating my, you're proving that you don't have any jurisdiction.
So this is a detailed advisement should you wish to waive your right to have counsel present and you want to act as your own attorney.
I said over and over again that I'm here sui juris and propria persona. You know what that means.
This case is going to be going to trial, so you need to have counsel.
I'm here of my own right in my proper person. You know what that means.
So there's the form.
I've never signed my power of attorney away to anybody, especially this.
You need to be respectful. You are really out of line, Mr. Schuster.
I didn't say anything disrespectful.
You are being very disrespectful.
You are being very disrespectful, actually,
because
you're violating my rights.
So I'm going to set this on for the August term. I'm going to have you take this form.
Wasting my time.
Mr. Schuster.
And you're taking away my ability to provide.
The judge has now made something very clear. The case is moving forward whether Jonathan agrees with that reality or not. That's an important lesson because many sovereign citizen arguments are built on the assumption that personal consent is required before courts can exercise authority. But courts don't generally function based on individual approval. If they did, anyone facing charges could simply refuse to participate, and the legal system would grind to a halt. Instead, courts operate under laws established through governmental authority and constitutional frameworks.
You're not free to leave yet, Mr. Schuster.
I'm not free to leave?
Not yet. No, you're not.
Why am I not free to leave?
Because we are still addressing your matter.
This matter needs to be dismissed.
Yeah, it's not going to be dismissed right now. So right now it's getting set for trial.
You can't move any further until you prove jurisdiction.
And the readiness hearing will be July 31st. And that will be at 2 p.m. And that hearing, Mr. Schuster, is on Zoom.
Any jurisdiction over me whatsoever. I've not pleaded. I've not given you personal jurisdiction.
Yes.
And you practice law on the bench.
So, Mr. Schuster, if you choose not to come to your court hearings, a warrant will issue for your arrest.
You're threatening me again, telling me
yes,
if I don't
you will be expected to appear.
And you just said yes. Oh my goodness. That if I don't play your game, you will put me in captivity. This is ridiculous. Absolutely ridiculous.
Yep. These are jailable offenses, but for this hearing, we need your presence to appear.
Absolutely ridiculous.
All right, let's get a court date form for him.
Absolutely ridiculous.
What's the date for the intervening?
Back there?
We can set a pre-trial. Let's do it on the 22nd.
Prosecuting attorney also needs to provide any contracts that I've entered into internationally.
Here's your court date. Could you please sign?
Especially if this is an admiralty maritime jurisdiction, which obviously by the gold fringe flag it is. So,
Mr. Schuster, you are in a criminal court, and there are court rules. If you wish
this is a criminal matter,
Mr. Schuster, if you wish to have discovery, then you need to abide by the rules.
Criminal matter?
Yes, and if you wish to have
okay. I wasn't sure you said that.
Criminal matter. If you wish to receive discovery, then you will need to make.
What is the jurisdiction? Are we under an admiralty maritime jurisdiction?
No, we are not.
Are we under a common law? What jurisdiction are we under?
We are under the criminal jurisdiction of the state of Washington. So if you wish to have discovery, then you need to request.
I gave you my permission to be under that jurisdiction, which I haven't.
You will need to request discovery from the prosecutor's office.
I'm a U.S. citizen, American national. That's not a jurisdiction.
If you wish to have discovery, you need to request it in writing from the prosecutor's office, and we will send.
Your nationality was a U.S.
And then we will send you the discovery, all of the evidence that we have against.
What we've witnessed here is a textbook example of the clash between sovereign citizen beliefs and the realities of the legal system. Throughout both hearings, Jonathan repeatedly challenged the court's jurisdiction, referenced trusts, contracts, and special appearances, and insisted that the case could not proceed until the court answered his questions to his satisfaction. Despite numerous interruptions and repeated jurisdiction challenges, the judge consistently moved the case forward and made it clear that legal proceedings would continue according to established law.